You're listening to State of Arrest with South Florida criminal defense attorneys William R. Moore and Billy DiRenzo.
Good morning.
Good morning, Bill. All right, so listen, in the past, talking about years ago, there was hard time for DUIs, and I'm not talking about it in incarceration, but as it pertains to driving without a license in general. There's 30 days you had to go without a license or 90 days in the past. Tell us a little bit about that and how it's changed.
Well, what they've done, prior to, I believe it was July 2013, if you were arrested for DUI, you had to apply for a formal review hearing if you wanted to preserve your driving privileges. Formal review hearing is a hearing that you can apply for with the DMV that will give you an opportunity to challenge the suspension of your driver's license.
Now, it used to be a lot easier to beat these things, right? If the officers didn't show up, you'd get an automatic, they'd rescind the license suspension and all was good. You still had to fight the DUI, but you would have a license and not have to do any hard time and not go without any suspension, go with suspension.
Yes, at that formal review hearing, they used to be a lot easier to beat. A lot of different things have changed, but as you said, officers not showing up, problems with paperwork, things like that. It seems like they've clamped down and they've become much more difficult. Now, what they've done as of July 2013 is they've given first-time offenders, meaning the people that have been arrested for a DUI for the very first time, if this is their first arrest, they can go into the DMV and they can apply and get an automatic hardship license. That license will be good for going to and from work, to and from school, religious, educational, medical, any type of necessary driving that they need to do. So that will essentially keep a first-time offender driving throughout their entire suspension. For example, first-time breath test over the legal limit, you are getting a 6-month suspension. First-time refusal, you are getting a 1 year. So for that entire 6 months or 1 year, you will be able to drive for those limited purposes.
Now, you've got to waive your right to a formal review hearing.
Yes, good point. You can still have a formal review hearing if you so choose. That is still an option for those first-time offenders. But in my experience, most of the time, people cannot take that risk and they just go with the hardship license. But that's up to the individual.
It's tremendous incentive.
Oh,
You get an automatic
yes.
hardship license as opposed to having to go 30 or 90 days without any form of a license whatsoever.
Yes, and you're talking about the hard time. So if we do go to a formal review hearing and we happen to lose that formal review hearing on a breath test above the legal limit, a 6-month suspension, you get a 30-day hard time period. On a refusal, you get a 90-day hard time period. Here's what the hard time period is. That means that you cannot drive for either that 30 days or that 90 days. No driving whatsoever. You can't take your kids to school. You can't drive to work. Can't drive to medical appointments. No driving for that time period. So yes, as you said, it's a tremendous incentive. It guarantees that that individual who is arrested for DUI is going to be able to drive for those limited purposes, at least getting to work and getting their kids in medical appointments and things like that.
Now, when it comes to driving on a suspended license, driving on a DUI suspension, getting cited for that or even arrested for that, that's significantly different than, let's say, failing to pay traffic tickets, right?
That's huge.
It's huge, right? You're going to jail.
Difference.
You're going to
Huge
jail
difference.
if you're
Yes.
convicted for that, right?
Truthfully, even if you are pulled over for that, most of the time you go to jail for driving on a suspended license on a DUI. Now, the police officer obviously has the discretion whether he wants to arrest you or not, but 98% of the time you're going to get arrested for that. Now, if you get pulled over for driving on a suspended license for unpaid tickets, you then have the option that the police officer could give you the leniency of saying, well, you didn't know, and you could get a traffic infraction for that, unknowingly driving on a suspended license. But if it's knowingly, police officer still has the option of not taking you to jail. But yes, on the DUI suspension, once you get into court, they are going to try to put you in jail. Every prosecutor, at least in Broward and Palm Beach County, is going to offer jail time on that.
Yeah, driving on a suspended license as a result of a DUI.
Yes.
That there's no without knowledge because you knew.
You knew.
You knew your license was suspended.
Yes, because you took the plea in the courtroom most of the time. 99.9% of the time, you were standing there when the judge told you, hey, Mr. So-and-so, Mrs. So-and-so, your license is suspended.
Bill, thank you so much. Until next time.
Awesome. Thank you.
You've been listening to State of Arrest with South Florida criminal defense attorneys William R. Moore and William DiRenzo. Catch us next time. We'll talk more about DUI laws and laws in general, criminal defense, prosecution. Until then.